Hi everyone, my name's Georgie Chapman. I'm a partner at HR Legal and I'm an employment law and occupational health and safety lawyer. And today I'm going to be taking you through the legal compliance framework when we're managing an ageing workforce. Now, I'm really passionate about not just minimum legal compliance, but assisting organisations to move into the best practice space. So I look forward to exploring this with you today. In terms of what we're going to cover today, firstly, we'll look at occupational health and safety and what the minimum obligations are and how you can meet those obligations when managing a mature workforce. Secondly, we'll explore anti-discrimination legislation and the protections on discrimination on the basis of age or disability in the workplace. Thirdly, we'll look at managing the risks in terminating the employment of older workers, particularly where they don't have capacity to fulfil the inherent requirements of their role. And finally, we'll look at flexible working arrangements and how these can be harnessed in continuing to engage a mature workforce when they are moving towards retirement. So in terms of occupational health and safety, there's legislation at both state and federal level around occupational health and safety in the workplace. And broadly speaking, the overarching obligation on employers or persons conducting a business or undertaking is the same in that they must provide and maintain, so far as is reasonably practicable, a safe working environment for employees and workers. And when we're talking about health and safety in the workplace, this covers both physical and psychological safety. And this has always been the case under legislation, but perhaps hasn't always been recognised as readily in workplaces around psychological safety, perhaps because there's been less comfort around talking about mental health and mental illness, but also because psychological conditions are less visible in the workplace. But it's really important to emphasise that we need to have measures in place to protect both physical and psychological safety. So what this requires is that employers proactively manage risks and identified hazards as far as reasonably practicable. And what that really requires is to be proactive in the workplace. We're not just waiting for incidents to occur. And this is particularly important in the context of monitoring health of employees. So it's not just about having in place measures that protect health and safety at the outset of employment. However, we need to ensure that workers are fit and safe to continue to fulfil the inherent requirements of their role on an ongoing basis. It's really important also to emphasise that individual workers have their own obligations to take reasonable care for their own safety and for that of others in the workplace. That includes other employees and also visitors or customers. Risks in terms of health and safety obviously have very real consequences for individuals if incidents occur, but they also have legal ramifications. This may include investigations or low-level compliance action by the safety authority, and it might even result, in the case of serious incidents, in prosecution and criminal sanctions being imposed on both the company and individuals involved in the breaches. But what we more commonly see, particularly when managing an ageing workforce, is that individuals may make workers' compensation claims. And what we know, particularly where there can be physical conditions that relate to age-related degeneration, that can be quite difficult to manage, particularly if you're trying to rehabilitate workers to come back to full capacity to fulfil the inherent requirements of their role. And what we also know around psychological conditions, and this applies at any age, that these can be very difficult claims to manage, particularly if someone is absent from work for more than 13 weeks. The statistics around employees being able to be rehabilitated to fulfil the inherent requirements of their role in those circumstances are relatively low. So it's really important that we're taking proactive steps to avoid these sorts of claims being made in the first place. So in terms of managing an ageing workforce, some really key components of meeting your safety obligations include your pre-employment processes. And what we suggest is that you're not just providing pro forma pre-employment questionnaires where it's essentially a tick and flick form that asks a number of questions, perhaps, do you have any particular injuries or conditions such as diabetes or a heart condition? Can you lift particular weights and the like. What we suggest these sorts of processes engage in is asking questions such as, does the applicant for employment have any pre-existing injuries or conditions that may prevent them from fulfilling the inherent requirements of their role? And that enables the employee to make a fully informed disclosure. But of course, in order to do so, you do need to actually inform them what the inherent requirements of the role are. And we'll explore what inherent requirements means in just a moment. We also suggest that you ask questions around whether they're at risk of any exacerbation of a pre-existing injury or condition if they're required to fulfill the inherent requirements of their role, or if there's any other risk to their health and safety should they be required to fulfill the inherent requirements of the role. This should arm you with important information around the employee's capacity for work, and that's really important from a safety perspective, but also in terms of making reasonable adjustments, which is also a requirement under anti-discrimination legislation, and we'll explore that in due course. Also really important is that you're continuing to monitor health of employees, as I mentioned before. And if you have concerns about their capacity for work, it may be appropriate that they are directed to undergo a fitness for work assessment. And if that's the case, it's really ideal to have this built into your employment framework, including policies and procedures and employment contracts. Really important is that if you're monitoring health of employees, that you start conversations around fitness for work at an early stage. While it might be built into your employment framework, including policies and procedures, contract of employment, like I mentioned earlier, sometimes these sorts of conversations can be quite confronting for the individual concerned. So it's important that you raise concerns at an early stage, and particularly when we're dealing with an ageing workforce where there may be concerns about the ramifications for their future employment, that this sort of conversation is coming from a supportive place, and it's really about ensuring that they're healthy and safe in the workplace. And when these assessments are taking place, it's really important that they are undertaken against the inherent requirements of the role, so that the party who is undertaking the assessment understands the nature of the role, what is required, and the context around the conditions in the workplace, so that they can provide a fully informed opinion around that person's capacity and safety at work. So now I'd ask you to reflect in your group, what are the principal risks in your workplace when you're dealing with an ageing workforce? Do you think these are heightened with age, or are they the types of risks that are present at any age? So now we're going to explore what are the inherent requirements of the job, and you will have heard me mention that term a number of times, and I'll continue to do so throughout today's discussion. So the inherent requirements of the job are essentially the key physical, cognitive and psychosocial components of the job. So these are wide and varied and will very much depend on each individual role. Now, traditionally, when employers had someone assessed as to whether they could fulfill the requirements of the role, often there would be reference to a position description. Now, a position description is very different to the inherent requirements of the job. Generally, that will refer to the day-to-day duties that the employee is required to undertake, and it might also refer to things such as key performance indicators and the like. However, the inherent requirements of the job really state the essential components of that role from the physical, cognitive and psychosocial perspective. And also, often what we see traditionally is that the inherent requirements of the job are really focused on physical, but as I emphasised earlier, when we're talking about safety, it's both physical and psychological safety. So we do need to cover the full spectrum when we're mapping out the inherent requirements of the job. And as I said earlier, this is really important in the pre-employment process. So when you're asking questions around capacity of an applicant to fulfill the requirements of their role, they should be provided with a copy of the inherent requirements so they can make that fully informed disclosure. Likewise, when you're undertaking fitness for work assessments, whether in the pre-employment phase or during employment, there should be reference to the inherent requirements of the job. And also when you're managing workers' compensation claims, the inherent requirements are really important in terms of tracking that person's capacity for the inherent requirements of their role, but also for suitable employment and providing them with suitable duties towards rehabilitation. So I've got a case example to really emphasise the importance of robust pre-employment safety processes. And this was a case where an applicant was applying for a role as a coach driver. Now, the applicant was diagnosed with a pre-existing mental health condition. However, when he filled out the pre-employment questionnaire, he didn't disclose this mental illness. Part of the pre-employment processes then required him to undergo some fitness for work assessments and a medical assessment by a doctor. And part of those processes also required that he undergo a drug and alcohol test, and that revealed that he was taking prescription medication. Now, when he was questioned on this, he became quite escalated, and he was assessed by a doctor ultimately as being temporarily unfit to fulfill the inherent requirements of his role. But there was the suggestion made by the doctor that perhaps this should be verified by a psychiatric assessment, given the nature of his condition. At that juncture, the prospective employer made the decision not to employ him on the basis of that doctor's assessment. The prospective employee then made an anti-discrimination claim, and he was successful on the basis that he could fulfill the inherent requirements of the role, and he'd been discriminated against on the basis of his mental illness. Now, in that case, he was awarded $10,000 compensation, but aside from that, the prospective employer also had to go through the process of defending that claim, and it was, of course, on public record. And I think this is a really good case at emphasising a prospective employer who'd done a number of really good things around fitness for work in the recruitment phase. However, they'd fallen at the last hurdle. So where there'd been that opinion from the doctor that he was temporarily unfit without further psychiatric assessment, the employer chose not to undertake that further psychiatric assessment, and it's quite likely on the basis of the outcome of that decision that had they had him psychiatrically assessed, then it would have been revealed that he could fulfill the inherent requirements of the role. So I think it's a really good case that emphasises that it's really important to have robust processes, and that you do need to consider opinions provided in the scope of those processes, and if there are concerns about what a particular opinion means for that person's fitness for work, then actually seeking clarification and potentially a further opinion. So in summary, it's really important in terms of occupational health and safety that you're taking a really proactive approach and not just waiting for incidents to occur. Monitoring health of all workers, but particularly an ageing workforce, is really important, and building a culture around having conversations around fitness for work. So not just about enacting these sorts of processes in a punitive fashion, but making it part of the culture so that you're continuing to have conversations around fitness for work, both psychological and physical. Safety is fundamental irrespective of a worker's age, and that's really important to remember. Safety really is the overarching obligation, and when you're undertaking any of these processes, safety is always the justification. Some prompts for further action might include some visible signs that the person may not be fit to fulfill the inherent requirements of their role. It might be that they're complaining of physical issues such as back issues or other musculoskeletal issues. There may be absenteeism patterns that reveal that perhaps someone doesn't have fitness for work on an ongoing basis. There may also be some minor incidents or accidents that are occurring that are out of character and warrant a further conversation. And when we're dealing with psychological safety or potential mental health conditions, it might be that changes in behaviour, performance, or how that person's presenting at work may be red flags that are worthy of a conversation. And as I said earlier, it's really important that when you're instigating these conversations, it's not coming from a place of punitive action. So by an example, if someone has had an accident or an incident, it's not about going straight to, what are the disciplinary consequences for that, but also pausing to consider, are there other things at play here that we need to have a conversation, and actually holding space so that person can make a disclosure if they are experiencing a health condition that might impact their safety at work.
Audio Jungle.